FBI Director Kash Patel could not answer whether Donald Trump was on Jeffrey Epstein's client list, and his evasions revealed something far more troubling than any single name. What happens when a congressional representative uses sharp questioning to expose the gap between promises of transparency and the reality of what's been released? And why did the FBI director repeatedly refuse to confirm whether he'd personally reviewed all the material seized from Epstein's Manhattan safe? Join us as we break down Ted Lieu's masterclass in congressional oversight and reveal why this exchange represents a massive red flag for government accountability. Section 1, the safe discovery. The FBI searched Jeffrey Epstein's Manhattan residence in 2019, discovering a safe that contained topless and lewd photographs of girls. This isn't speculation or rumor. The New York Times reported on July 8, 2019 that a trove of photographs of girls was discovered in a safe inside financier Jeffrey Epstein's Manhattan mansion. This became public knowledge through media reporting at the time. Director Patel confirmed the search occurred, acknowledged the FBI found a safe, but repeatedly deflected when asked about specific contents. His responses followed a careful pattern. "I'll accept your representation, and I don't have the catalog of evidence in front of me." These aren't answers, they're techniques for avoiding answers while appearing cooperative. Ted Lieu established this foundation deliberately. He needed to confirm basic, undisputed facts before moving to more difficult questions. This is how effective congressional oversight works. You build a chain of acknowledgments that make evasion on later questions more obvious and more damaging. The significance of the safe cannot be overstated. Epstein didn't keep random materials in a locked safe inside his mansion. People secure things they consider valuable, sensitive, or incriminating. The contents of that safe represent potential evidence of crimes and potential leverage over powerful individuals. Section 2, the Michael Wolff testimony. Author Michael Wolff conducted numerous interviews with Jeffrey Epstein before his death. During one of these interviews, according to Wolff's testimony, Epstein went into his safe and retrieved photographs. Wolff described them as Polaroids that Epstein spread them out like playing cards. The images allegedly showed Trump with girls of uncertain age at Epstein's Palm Beach house, the same location where many of Epstein's alleged crimes occurred. Wolff provided specific details. He described seeing approximately a dozen photographs. In two of them, topless girls were sitting on Trump's lap. In a third photograph, Trump had a stain on the front of his pants, and the girls were pointing at it, bent over laughing. These are extraordinarily specific claims from a journalist who interviewed Epstein multiple times. Ted Lieu asked Director Patel a simple question. Are there any photos showing Donald Trump with girls of uncertain age? Patel's response was categorical, no. But when Lieu pressed on how he could be so certain, Patel claimed that such information would have been brought to light by multiple administrations and FBI investigators over the course of the last 20 years. This reasoning is fundamentally flawed. Ted Lieu immediately pointed out the obvious counterexample. Nobody knew about the creepy birthday message that Donald Trump wrote to Jeffrey Epstein until the Wall Street Journal disclosed it, and then suddenly the Epstein estate provided it to Congress. The existence of that message proves that material can remain hidden for years, despite multiple investigations. Section 3, the evasion pattern. Director Patel wasn't present at the search of Epstein's residence. He doesn't know what Epstein may or may not have done with photographs before the search occurred. Maybe someone has them. Maybe the Epstein estate has them. These are reasonable possibilities that Patel's categorical denial ignores. When Ted Lieu asked whether the FBI had interviewed Michael Wolff about what Epstein showed him, Patel responded, "I haven't personally asked to talk to Michael Wolff. I'll get back to you if the FBI has." This is remarkable. An author publicly describes seeing evidence of potential crimes involving high-profile figures, and the FBI director doesn't know whether anyone has interviewed him. Ted Lieu asked whether the FBI subpoenaed the tapes that Michael Wolff recorded during his interviews with Jeffrey Epstein. Patel's answer, "I don't know." These tapes could contain Epstein's own words describing criminal conduct, naming co-conspirators, or discussing the photographs Wolff saw, and the FBI director doesn't know whether they've been subpoenaed. This pattern reveals something important. Either Patel genuinely doesn't know basic facts about one of the most high-profile investigations in FBI history, or he's deliberately avoiding confirming information that would create political problems. Neither explanation is acceptable for someone in his position. Section 4, the estate excuse. Ted Lieu pressed on a critical point. The estate of Jeffrey Epstein has a voluminous amount of information they haven't released. Shouldn't the FBI subpoena that material? Patel's response was that the estate is under no obligation to provide that material even pursuant to a subpoena. Ted Lieu's reaction was immediate and correct. That's just false. You're the freaking FBI. You can subpoena the information from the estate and you better do that. Patel tried to insist that's literally not how it works. But he's wrong about the law and wrong about investigative practice. The FBI absolutely can subpoena materials from estates. Courts can compel production of evidence relevant to criminal investigations. If the estate refuses, the FBI can seek judicial enforcement. If courts rule that certain materials are privileged or protected, those rulings become part of the public record that can be reviewed. Patel's claim that the estate faces no obligation to comply with subpoenas suggests either profound ignorance of federal investigative powers or deliberate misrepresentation designed to justify inaction. The FBI subpoenas materials from reluctant parties constantly. It's fundamental to federal law enforcement. Section 5, the client list question. Ted Lieu moved to perhaps the most politically sensitive question. Is Prince Andrew on Epstein's client list? Patel responded that the material related to Prince Andrew has been made public. That's not an answer to the question. Lieu asked again, is Prince Andrew on the client list? Patel deflected, we have released the index of names. Then Lieu asked the question that made this exchange go viral. Is Donald Trump on Epstein's client list? Patel's response, the index has been released and the index will speak for itself. He refused to give a yes or no answer to a direct question about whether the current president appears on a list of Epstein's associates. This evasion is a huge red flag. If Trump is not on the client list, Patel could simply say no and end the speculation. If Trump is on the list, Patel's refusal to answer protects the president from accountability. Either way, the American public deserves a clear answer, not bureaucratic word games about indexes speaking for themselves. The phrase client list itself requires clarification. Does it mean people who received illegal services from Epstein, people who flew on his plane, people who visited his properties, people who received financial services from his legitimate business? Without defining terms, even a released index might obscure more than it reveals. Section 6. What transparency actually means. Ted Lieu's questioning exposed a fundamental problem with how officials discuss transparency. Saying we released what we legally can is not the same as demonstrating why other releases would break the law. If court orders or grand jury rules actually bar release of certain materials, the public should be shown those orders and the legal basis. Real transparency in this context doesn't mean publishing victims' identities or illicit material. It means pursuing every investigative lead, interviewing journalists who claim Epstein showed them evidence, subpoenaing tapes and unique materials, and creating a public record of what was done and why certain avenues couldn't be pursued. Transparency operates in a trauma-sensitive way through redacted witness summaries, indexes of seized items, and court filings that explain why sealing remains necessary. These kinds of disclosures protect victims while allowing the public to evaluate whether an investigation was robust or deliberately limited. The Wall Street Journal's disclosure of Trump's birthday message to Epstein illustrates the problem. New documents can surface years after investigations supposedly concluded, and a state's voluntary cooperation is not a substitute for vigorous legal action when the public interest is weighty. If the FBI didn't attempt to compel production, that decision needs explaining. Section 7. What should happen next? Congressional oversight should demand specific, concrete actions that preserve victim privacy while raising public confidence. First, request a categorized inventory of what was seized from Epstein's properties. This includes files, computers, tapes, Polaroids, FBI 302 interview summaries, and financial records, with clear indication of what remains under seal and the specific legal authority for each seal. Second, demand copies of any motions filed to unseal materials or seek redactions tailored to protect victims, along with tracking of court responses. If the FBI sought to release material and courts denied it, those orders should be public. If the FBI never sought release, that inaction needs explanation. Third, request that the FBI state whether it has subpoenaed the Epstein estate for previously unreleased materials, and if not, why not? Fourth, push for redacted 302s or an index of witness statements where possible. Redaction can hide names while revealing whether interviews contained leads implicating other people. Fifth, seek confirmation whether journalists or authors who say Epstein showed them material have been interviewed or subpoenaed, and whether recordings or tapes have been sought. Michael Wolff is one example, but there may be others who had direct access to Epstein and could provide evidence. Section 8. The accountability gap. This exchange shows how rhetorical promises can turn into procedural opacity once someone takes office. Campaign pledges about releasing documents transform into explanations about legal constraints and estate control. The gap between promise and performance deserves scrutiny, regardless of which administration or political party is involved. If elected officials truly want confidence restored, they should stop accepting evasions and start demanding records, motions, orders, inventories, and timelines. Congressional oversight that produces documents rather than talking points serves the public interest. Oversight that accepts "I don't know" and the index speaks for itself serves only those who benefit from opacity. Survivor-centered transparency is possible. Independent victim advocates can review materials and help design anonymized summaries that don't re-victimize. The tension between public accountability and victim protection is real, but it's not insurmountable. Officials who claim these goals are incompatible are often just avoiding accountability. The American public deserves better than what this hearing revealed. When the FBI director cannot or will not answer basic questions about whether key investigative steps were taken, something is fundamentally broken. Ted Lieu's questioning exposed that breakdown with precision and persistence. FBI Director Kash Patel repeatedly evaded direct questions about whether Donald Trump appears on Jeffrey Epstein's client list and whether the FBI pursued obvious investigative leads like interviewing Michael Wolff or subpoenaing the Epstein estate. The question is, will Congress demand the categorized inventory, court filings, and witness summaries that would show whether promises of transparency were followed by concrete legal action, or will officials continue accepting bureaucratic evasions instead of documented accountability? Drop your thoughts in the comments. And if you want justice to be accountable and survivors' rights respected, raise your voice with your representative to demand the documents, not just talking points. Make sure you're subscribed for deeper analysis of how unsealing works and what Congress should compel next. Thanks for watching.